So, pinaliwanag ko po yun dun sa aking dissenting third opinion on Hacienda Luisita, na wala ho talagang katotohanan ni Conte yung nais kong pahirapan ang magsasaka. In fact, doon sabi ko, regardless of the issue of just compensation, distribute. Kasi yun ang mandate ng batas, i-distribute na po.
Okay. Salamat po. Dalawa na lang po ito. Napakarami nitong tanong sa inyo, pero aabutin tayo ng gabi pag tinanong ko lahat. Dalawa na lang po ito. Justice Sereno, Justice Abad, the other day, gave his docket output. Now, what is your output in terms of decision this year?
Okay po. Alam nyo, nung nagsimula po ako, ang opisino pong binigay sa akin ay ito.
Ito.
Ang akin
so,
pong...
memorable pala itong
Opo!
lugar nito.
Dito po ako in-interview noong 2010, maalala nyo po, Justice. Tapos dito rin po ako nag-umpisina. Kaya po kayo nung nag-interview po kayo sa taas kayo.
Oh, yes.
Diba? Na-eject ko po kayo.
Oo nga.
Ang akin pong chamber, hinati lang po ng isang blackboard. Andito po ako.
I see.
Isipin nyo po ang sitwasyon ng isang justice na ganun po ang kondisyon. So yung pangangapa ko sa trabaho, nagdagdagan po ng hirap ng physical facilities.
Okay.
So, nagsimula po nagkaroon po ako ng tunay na opisina nung Mayo.
Nitong
2011.
Okay.
So isang taon hong ginawa ko yung mga kailangan gawin. So, ang akin pong production, maaari po ako magbasa ng statistics, no? Nagpadala ho ako kasi ng updated figures. Kasi ang nangyari, nag-usap po kami ng staff, ano ba ang talagang tama? Kaya nung July 17, binigay ko po ang figures sa inyo, no ho? Tung May 2011 up to May 2012, may 451 decisions, signed resolutions, dispositive minute resolutions, and separate opinions po ako. At umangat ho ng malaki yun, nung June 2012, naging total of 529. Okay. So, ang average monthly output ko po ay 45 of all those collective outputs, and then tumaas po ng 48. Okay. Ngayon, matapos po nung decision writing break namin, nag-hit po ako ng historic high. Yung aking monthly output po ay naging 78 po.
Wow.
So, dun sa 78 po, kung hindi po ako nagkakamali, 27 full-length decisions po yun. So, in other words, yung, kumbaga yung isang makinang yun naman po, yung nakaarangkada po na tawag natin.
Nakaintindihan ko yun.
Opo, salamat po.
So, kumbaga sa makinang umarangkada.
Opo. Okay. In terms of numbers po, napaka-hopeful ko po, no, na at the end of the year, yung aking case output po, wala nang aged case. Okay. Inuna ko po kasi yung pinaka-luma na kaso na napakahirap, yung mga files po ng isang buong trolley. Wow. Gaya po ng kaso po na kasama po ng si Honorable Musngi po. Ano po yun? Alam niyo po yun, 2002 po. Ako po ang pangwalong ponente. So, ito po yung mga kasong pinagpasapasahan. Doon sa pong isang kaso na inattach ko po sa inyo, yung Urban Bank, Magdaleno Peña versus Urban Bank, ako po ang pang-15 ponente. Wow. So, at nandun po yun, noong 2001 pa. So, matagal po rin ang ginugol ko doon sa mga luma, napakahihirap na mga kaso. Kasi, the longer it stays, the more the sense of injustice felt by all parties intensifies.
Ito na lang po ang pangalawang katanungan na nakita ko dito sa Twitter. Justice Sereno, what is your opinion on the insider-outsider issue in the appointment of a Chief Justice?
Yung Constitution po parang hindi po fully embodied ang lahat ng qualities na, or hindi po defined ang field of choices na pwedeng pag-isipan. Totoo naman po na may advantage ang insider. Dahil po, kumbaga, you are talking of an institution na masyadong unique. Yung amin pong deliberations, sui generis po, ibang klase po. for an outsider to understand how to manage the agenda of the NBank and the divisions, hindi po nakakashock po na masyadong specialized po yung experience na yon. Kung po ang outsider ang ilalagay po natin, parang nag-appoint kayo ng civilian na mag-head ng isang gera.
Okay.
Imbis na general naman po sana, no? So, ganun po yung insider-outsider debate. Now, dun naman po dun sa define, kung insider ka naman, bakit ka naman sinasabi na, yung, may mga masasama rin naman po silang pinag-iisipan about an insider. Tiningin ko naman po nung sinabihan po, nung nag-public approval po yung appointment ko noong 2010, pinag-isipan ko po, yung fresh wind po ba na sinasabi nila, naging stale na, or is it still fresh? May isa pong kolumnista nagsabi na, para pong pumasok na ilaw sa madilim na kwarto. Para pong, in other words, yung expectation po ng mga tao na aking gagawin, na-maintain ko po. So, sana po makita ng mga tao na marami hong mahuhusay na huwes. Reform and strength can come from within.
Okay. Salamat po, Justice Serena.
Salamat
Thank
po,
you very
Justice.
much and good luck. Okay.
Justice Herr Musisimak, sir.
Good afternoon, Justice
Good
Serena.
afternoon po, Justice.
I hope you will not place me at a disadvantage because I am a Cebuano.
Ay,
Presently, cases which are not necessarily decided en banc are decided by a division of the Supreme Court. The decision of the ponente in that division is considered a decision of the whole court. There are objections to this manner of deciding cases because it is felt that the decision of a division is not reflective of the sentiment of the whole court. What are your thoughts on this matter? Would you agree that all cases be decided en banc instead of by division?
may I proceed, sir?
Go ahead.
It is constitutionally designed that we are allowed to sit in divisions of 3, 5, or 7. But I would think, 3 or 5. But I would think that, and the decision of a division is considered as the decision of an entire court. It is not a subpart. It is as if the court is acting as a whole. Now, with the caseload that we have, where you have agenda items that runs in the hundreds for every session, whether it is en banc or by division, that kind of division of labor is necessary for the moment, Justice, for the moment. Now, that being said, I think the underlying problem with that concern is because decisions can conflict with the decisions of another division. In other words, there is no mechanism for the leveling off so that the uniformity in jurisprudence can be ensured. What I propose to create is that I will have a body of experts who will sit with us and identify for us the decisions that we have rendered that conflict with each other. The second thing is to either create a written manual or an intelligent software that will give red flags on when these possible conflicts are have already arisen with the petition that is before us. This body of experts, these consultants, will just alert us that there is now either an occasion for us to correct the conflicts in our decisions so that the ponente in charge and the division chairman can ensure that the end goal of trying to create a rational, standardized system of looking at substantive law is pushed. There will be an aid, there will be a mechanism to address that. So, For now, my take on this is that we have no choice. It is a practical problem, and it must be addressed by practical means. You know, if we are going to compare the judiciary to an organism, and the mind of the judiciary is in the collective membership of the Supreme Court, then that mind must first be stable and consistent. It's necessary. If we are to be believed by the people, we really have to be consistent in how we make decisions. An additional mechanism must be created, because if you are going to make all of the decisions decidable only by the en banc, then you will multiply the amount of time required for any decision that is ordinarily with the division to be adjudicated. That is it. That's my answer, Justice Hermosissima.
On another matter, considering the unmitigated proliferation of deaths caused by violence of judges, journalists, and other private individuals, are you in favor of the revival of the death penalty law?
If you will allow me, Justice Hermosissima, the constitutionality of a law that may be passed reviving the imposition of the death penalty may come before us. My view of the role of a judge is a limited and humble one. It is not our role to make policy choices. We cannot replace communities' shared values with our own. Our duty is only to apply the law as we see it and to ensure that it conforms with the Constitution. Beyond that, our personal preferences and opinions should not really seep too deeply into making partisan choices for a position or another.
What has been your judicial philosophy, Mr.
I believe that justice, in order to be justice, must also be rendered in a credible manner. And that every justice and every judge must look to the North Star that the country has chosen, which is the Constitution, and uphold the enduring values that the rule of law contains. So the role of a judge is not to go into social experimentation, but rather it is to articulate those shared values in the decisions that are before him, not to replace them. Because when you see that the collective wisdom of the majority is larger than your own individual design and your own individual definition of what is right and wrong, you will see that while we may dig deeply and be radical in our work ethic and in our desire to do justice, there are limits that we must carefully observe. And a justice can only be rendered if the judge rendering it is himself credible. Justice must be lived not only by our decisions and opinions, but it must also be lived by a life, because there must be correspondence between the person rendering the opinion and the opinion's resonance to what is deep in our hearts as what conforms to justice.
Well, you need not write a book on that.
Forgive me.
Can you please shorten? Do you have any?
3 words,
shorten?
justice, if I may: vision, courage, accountability.
That's
And
better.
thank you so much, Justice.
It's just like the sign in the halls of the Supreme Court of the United States. Yeah, what you find there is emblazoned is equality under law. Here in the Supreme Court, we have, what do we have? Batas, Bayan. So, how do you shorten your
For the moment, I will
judicial philosophy?
I will live with those words for the moment. But if the leadership mantle happens to ever be given to me, it must be a collective battle cry.
Do you abide by the motto of the Integrated Bar of the Philippines, which says, no master but law, no guide but conscience, no aim but justice?
Those are beautiful words. I mean, they
Yes.
embody the best. How can one not agree with that? Oh, but one must not just agree with it. One must live it. So I do agree, Justice.
The problem there is that we write our decisions on the basis of law. All right, law, on basis of facts, applying the law involved. Now, if the law is not in accordance with your conscience, will you abide by the law?
I would think that it would be very, very rare for that to happen. Because if you are going to look at the preamble of the Constitution, it defines the qualities of the Filipinos. God-fearing, a lover of community and of self, asking the aid of divine providence, dreaming of a just society, dreaming of prosperity. Now, if you look at that preamble and you look at the Declaration of Principles and State Policies and the more operative articles, I find nothing there that contradicts my values. So I find it hard to imagine a situation where a law that is faithful to the Constitution will also violate my conscience. That being so, perhaps what in fact has contradicted my personal preference is when the facts on record and the evidence that has been given does not conform to my own preference. I have no right to impose my preference, even if my desire, my human desire is for one party to win over the other. I must simply apply the law as it is. For example, may I be given an example? In Hacienda Luisita, under the protest against the long-term ownership by a family of thousands of hectares of land was decried by several sectors as having been the product of historic injustices. There were questions about how the land was acquired. There were questions whether there was a violation of an agreement with government for the financing of the development of the hacienda. Now, you can see this in the internet, you can hear it in rallies, but the problem, Justice Hermosissima, is that we are not in a position to correct a historic injustice, if indeed it took place, if the facts and the evidence are not on record, and if it is not in issue. So regardless of what I feel about the history of Hacienda Luisita, I did not have the right to probe into something that the parties themselves have never fully litigated before us. I have to look at my role in a more humble and limited way. I cannot probe into that.
I have asked this question from other candidates, and I feel that yours has been the very adequate answer. Now, what is your concept of justice?
I don't think that...
Be careful
I'm
now,
sorry.
because as Disraeli said, when you define justice, you limit it. And if you limit it, you destroy it. But anyway, what is your concept of justice?
Thank you. As long as we are mortals, we try to mirror only what are the more permanent and enduring values of our Creator. So when we look at beauty in nature and beauty in art, it is actually our human soul aspiring to see something of the eternal. Our work as judges and justices is something similar to that. When an artist paints a beautiful picture, he is mirroring something in him that he knows is more enduring. When we try to render justice, we are also trying to mimic, replicate, copy the work of God, which is really justice, because it is really His. How can anyone requite past wrongs when we are handling cases? That is not our role. But to the extent that the rules of procedure allow it, to the extent that substantive law allows us to right wrong, we do it because our conscience compels us. And our training says that to a certain extent, I can give relief. And that is a limitation of the role that we have. And we must be grateful for that limited role. If in a certain measure God's justice is being felt through our work, that should be enough. And if it talks about the work of justice, then that is the work that is adequate before us. To apply the substantive law that is before us, because everyone is supposed to understand and know what these laws are, in accordance with the procedures that have been time-honored and followed, and then to the extent possible, render relief to the cry, to the internal longings of people for justice. It is a limited role, but it is beautiful because in our human limitation, we are allowed to do that.
In that note, thank you very much.
Thank you, Justice.
Secretary Mosngi, please.
Thank you, Mr. Chairman. At the outset, I'd like to disclose that the Good Justice Maria Lourdes Sereno was the ponente of a decision that involved me, which affirmed the acquittal
Yes.
of judgment of the Court of Appeals.
Yes.
And I am happy to meet you for the first time, Justice Sereno. So I'll take this opportunity to thank you from the bottom of my heart. You are, to me, a living proof that there is justice in our jurisdiction. That note, I have no further questions for Justice Sereno.
Good afternoon, magandang hapon.
Ganda pong hapon, Justice.
Okay. Una lang, i-correct ko lang yung sinabi mo na meron akong sinabi dito nagsisigawan.
Ay, hindi po ba nakita
Hindi.
ko po doon? Sige po.
Sinabi ko, heated argument lang.
Okay. Mainit na talakayan.
At kinonfirm ni Justice Tony Carpio. Ano?
Opo,
Okay.
totoo po yun.
Itong kasing tanong niya, ni Miss Karen Davila, dalawa pala ito Parang hindi siya kontento dun sa una. Kasi ganito ang unang tanong niya. Please explain why your numbers and just compensation for owners of Hacienda Luisita are more than double. Tapos meron sang sumunod na tanong, please explain your position and just compensation for Hacienda Luisita, how much should they be paid? Ano po? Kasi yung sinagot niyo po kaninang just compensation, para hindi maintindihan masyado Kasi ang just compensation po, kung tama man ako, hindi lang ho based value ng property
Hindi po.
Ang just compensation po, based ang value ng property at the time of taking.
Opo.
Yun ang namimisikonsuro nila yung decision nyo po noon, sa una, yung just compensation po, base sa value ng property noong 2006. Kasi that was the time when the park nullified yung stock distribution option. Ngunit ang decision nyo talaga, illegal yung SDO. Kaya lang sabi niya, illegal yung SDO, i-distribute natin sa mga farmers, kaya lang gagawin natin na valuation 2006. Okay? Yung kabila naman, sinabi, sige, illegal din yung stock distribution, kaya lang i-value natin 1989. So ngayon, pinag-compare ngayon. Ano ang valuation kung gagamitin natin ang unlawful taking, not unlawful taking, taking pala. Taking of the kasi lawful pala yan, lawful sorry. Naalala ko kasi kanina, criminal law, unlawful taking, TEP yan TEP. So ngayon, ang ginagawa nila, pinagko-compare. Kung ang just compensation, based sa 1989, mas mababa.
Opo.
Kasi yun ang value Kung just compensation naman, ibaba sa 2006, mas malaki. Hindi ho ba?
Opo.
But to the credit of Justice Sereno, Nung nagkaroon ng MR, hindi pa po. Pinag-aralan namin uli, kasi ang sabi namin, at nag-join kami, magkasama po kami. Ang sabi namin, sa tingin ko yung just compensation dapat hindi natin i-decide
Pinasukan.
sa Korte Suprema kasi
Opo.
factual.
Opo, tama
So,
po.
ang naging final decision namin po, at
Opo.
nag-iba.
Magaling po. Tama po.
Nag-iba si Justice Sereno doon sa una niya,
Aha.
sumama na sa amin.
Opo.
Ang naging ponente doon, yung magaling sa remedial law, sa eminent, sa Rutland Reform, magaling si Justice Bersamin,
Opo.
gumawa sa ng opinion.
Sumama
Na
po
ito
ako.
hindi natin pwedeng i-determine ang just compensation Ibalik natin sa husgado.
Opo.
Kasi may factual issues, natalo po tayo doon. Hindi
Opo,
ho ba?
talo po
Yun.
tayo.
Kaya sa tingin ko, yun ang gustong sagot ni Yun ang gustong maliwanagan ni Karen. Tama po ako.
Salamat po.
Oo, tama ba
Tama
ako?
po.
Oo.
Alam niyo po, ang naalala niyo po, ito naman, hindi naman po confidential ito. Ang sabi ko po dun sa napakagaling na eksperto natin sa remedial law at agrarian reform, sana noon mo pa sinabi yan. Nung sinabi po niya, pinag-iisipan po niya, nakita ko, napaka-wise po ng solusyon na yon. So I bow to the wisdom of your, Justice
Yun na nga
Bersamin.
Ang problema kong kaibigan kasi yun kaibigan din natin yun minsan sinusundan parati ng So, family man kasi yun So, yun ang nangyari.
Yeah.
So, yun ang sinasabi nila marahil.
Tama po.
Yun ang sinasabi nila marahil na yung compensation na computation mo double. Di po ba?
Hindi ho ako nakapag-compute talaga.
Kaya
Totoo
nga.
Hindi ko kayang mag-compute po.
nga.
Wala po
Kaya
sa
nga,
record. Opo.
sila ang nagko-compute based yung factors na yon.
Tama po.
Tama
po.
ba ako?
Eksakto po. Salamat.
Para-
Nakompleto po ang picture.
Okay. Kinukonfirm ko minsan may heated arguments. Natural lang po yan, di ba? Alay mo bukas,
Opo.
ganito bukas. Ngunit pag kumain naman kami sa NBank, alam mo naman, after the NBank session, kakain tayo. Alam mo, nangyayari doon, hindi ba? O yun Walang confidential. Wala nang confidential yun kasi
Lahat po ng kwentuhan.
kwentuhan na
nangyayari.
We forget everything. Wala nang kaso-kaso
Opo.
Kailan malungkot kung wala ako.
Ay, opo. Totoo po. Kayo po ang star. Yun lang po ang sinasabi ko. Kayo,
Yun na nga po
siya po ang star sa amin.
Tama po. Ito po, Ito po, Justice Melo, yung sinasabi nila, kinakailan daw natin ng Chief Justice, na healing justice,
Healing.
Hindi ho ba?
May naririnig po tayo na gano'n.
Maraming nagsabi, healing justice, lahat, mahirap mamili ng healing justice sa tingin ko, kung gano'n ang hinahanap natin, tanong ko kayo nag-ambisyon na Chief Justice, kaya ba natin kung tayo maging Chief Justice, maging healing Chief Justice tayo?
Ano po ba ang i-heal natin? Kayo na po ang nagkwento na masarap po ang tawanan natin sa lunch. Wala pong hidwaan sa amin. Sinabi na po ng isa sa amin na wala naman pong factions talaga. Meron pong quality sa mga justices ng Supreme Court na matapos ng heated argument po, kaya po namin kumain at magtawanan sa jokes ng isa't isa. Kahit po corny. So
Sa akin
magaling
na
ho-
original
Oh. So, ano po ba ang i-heal? Hindi ko kasi na-imagine ng outside world na kaya po naming magkaroon ng heated argument, kaya po naming maglabas ng napaka-strongly worded dissent, at pag nagsama-sama nung po kami, nagtatawanan po kami. Hindi po nila alam yon. Kaya akala po nila, kailangan natin kumpunihin kung ano yung nasa Supreme Court. Wala naman pong kailangan kumpunuhin So, hindi ko po naiintindihan kung anong, hindi ko rin po naiintindihan yung mga taong nagsasabing, ako po ang mag-heal. Ano pong hihil nila? Kailangan pong taliunin nila si Justice Peralta sa galing ng jokes niya. Di po ba? Yun po ang kailangan. Kasi, we have already come together. And what people fail to remember, Justice, noon pong nagkaroon po nawalan po tayo ng ating Chief Justice. Gabi po yun ng May 29. Hindi po ba right after, within 24 hours, less than 24 hours, we came together from our recess after lunch to move unanimously to ensure that nobody doubts that the court is in business. Wala pong nanumbat sa amin. Bakit ka kasi nagganyan? Bakit ka kasi nagganyan? Bakit mo ginawa yan? Wala po. Ni kaunting panunumbat. So ano po ang ihihil? Palagay ko, may qualities po ang sitting justices ngayon to really get along well with each other, but still maintain their independence in a collegial body. Salamat po, Justice.
No, magandang papakinggan yan, Justice Sereno. Ano, kaya lang yung first meeting natin noon, after that unfortunate or what, no? We call it unfortunate incident, nawala yung chief natin, ano po. Wala kaming dalawa ni Justice Bersamin
nga po
Webes yun lumabas sa media, nag-boycott daw kami Oo, gumagawa sila ng istorya, nag-boycott daw kami, we will not recognize buti na lang si Chief Tony
Opo.
That morning, tinawagan niya ako. Sabi ko, Chief Tony, pasensya na lang. At meron po kaming lecture sa Baguio City, sa environmental law. Dalawa kami ni Justice Bersamin
Opo.
Doon may konting bayad Kako Kaya pasensya na lang. Biro mo, hinahanap po kami dalawa nandun kami naghihirap. Mahirap magbiyahe doon at saka overnight, matutulog minsan mahirap magpaalam sa misis. Hindi balik kay Justice Bersamin, parati kasamang misis Ako hindi So, ibig sabihin, tama ho yun After the impeachment, asip natin we went